Good evening, everyone, and welcome to our seminar this evening. My name is Stephen Gallagher. I'm from the Faculty of Law at the Chinese University of Hong Kong. This event is co-organised with our colleagues, my colleague Thomas, who is from HKU SPACE, who's not feeling too well today. So thank you very much, Thomas, for helping organise everything as well. The seminar tonight is a seminar about innovation, innovation in judicial practice. The practice of the
civil
court.
procedure.
Civil procedure. Let me introduce you to our two discussants tonight. The first, we are very pleased to have with us the Honourable Mr. Justice Russell Coleman, Senior Counsel. He serves as a judge of the Court of First Instance of the High Court of Hong Kong. Prior to his appointment to the bench in 2019, he was called to the Hong Kong Bar in 1991 and elevated to Senior Counsel in 2006. He was appointed a judge of the Court of First Instance in 2019, and since 2020, he's been the judge in charge of the Constitutional and Administrative Law List. Noted for his bold decisions, his lordship has presided over landmark cases, spanning fintech innovation, human rights, and administrative law. So, yes, interesting to be here tonight. Yes, we should give a round of applause. Thank you very much for joining us. And then also we have Mr. Joshua Chew, who is, of course, a lawyer, a law lecturer, a technologist, specializing in fintech, digital assets, and Web3. He's been serving as a law tech lecturer with Hong Kong U SPACE. He's co-chair of the Hong Kong Web3 Association, legal advisor to Women in Web3 Hong Kong, and senior consultant at Synergy. Again, Joshua's been at the forefront of law and technology intersections, from leading successful defense in Hong Kong's first crypto litigation, modernizing some civil procedure with digital service via data rooms, which of course is what we're going to be talking about partly tonight, and again, contributing to a number of initiatives to do with real-world asset tokenization as well. So we'll get into the crypto world hopefully as well at some points. These are our speakers tonight. We should thank Joshua as well for coming in.
Thank you for having us.
So let's start with just a sort of a general introduction. The internet, when it first emerged, it was described as a Wild West, definitely early crypto world, with the anonymity that crypto can offer and everything else, has been described as the Wild West. What are the challenges of extending the rule of law and the basic ideas of justice into an environment that was originally designed to, if not let actors hide, at least to have a degree of anonymity?
Well, having heard the introduction for Joshua, I've decided he knows everything about this topic and can answer all the questions. How about going first, Joshua?
Well, the experience really stretched back to when I first moved from tech into the legal realm, where I had the privilege of working on one of Hong Kong's very first cryptocurrency-related cases. And one of the first issues that came out is I was defending the largest crypto exchange at that particular time. And one of the issues that we actually liaise with the other side is you shouldn't be suing as an exchange. I gave an analogy: just because your client might be this victim of a fiat fraud and it went to a Bank of China bank account, for example, it doesn't mean that you should list the bank as a defendant. Well, interestingly, the other side actually came back in one of their correspondences and asked, oh, sure, but how do we go about freezing crypto assets? Well, my initial position was, I'm not supposed to teach you, I'm on the defense side. But again, they brought up a very interesting point. And that is why I've worked on a number of cases where very fortunate to have His Lordship's decision in Hong Jun Sang, of course, it really laid the foundation for, one, how do you basically digitize the civil procedure process that enable us to take the step into digital space and begin orchestrating targets against people that are hidden behind the ether of cyber realm, of course. Now, going back to the very first crypto litigation, you guys will see me still in a suit and tie today. I always share this story. Back in 2018, I believe, after winning the case, the client actually offered to pay our legal fees in Bitcoin, but my partner at that time said Hong Kong dollar only, which is why I'm still stuck working to this very day. So having said that, I'll pass it back to the panel to carry on the discussion.
I think you asked about extending the rule of law into the environment, which involves originally designed to let people hide. And I think the rule of law is obviously designed to maintain and promote the right ideas of justice, and has sometimes been described as the light that you shine into the dark corners where people might otherwise behave in a way that is not acceptable to society as a whole. So extending the normal idea of justice into a new area is something that practitioners and judges together will want to try to work on. And to an extent, they'll be playing catch up throughout, and we'll perhaps come back to that a little bit later. But once they are getting up to speed and before the target moves on, then that is the opportunity to provide that extension and to promote and maintain the rule of law in a new area.
Thank you for that. The next question really builds onto that. It's the idea of, in practical terms, what does it mean for Hong Kong courts to extend justice into the realm of the internet and blockchain? Could you?
I think it means that, first of all, people have to try to understand as best they can what these things are. What is the internet? Maybe what is a blockchain? What is the blockchain? Not just a general idea, but obviously some level of detail about how each of them work, what can be done using them, and how people actually go about using them. Because without that practical basic knowledge, at a very minimum, it's very difficult for any court, I think, to bring justice into that area.
And for practitioner, it's actually our duty to assist the court in understanding and articulating where the assets, for example, are located, meaning identifying the perpetrator within the digital space. So we have new, of course, I'm an advocate saying that existing common law is more than sufficient for us to pinpoint how the court may actually give us the relief that we're seeking in order to basically conduct asset recovery operations. But of course, it's down to us explaining the proper steps, how it can be, for example, how an entity can be properly painted, canvassed, identified through a wallet holder, for example. And by these means, and by the very fact that, and one of the key factors, of course, is turning what traditional service of legal documents, for example, is a very physical paper-based operation. But one of the unique features that led to so much more, that enabled us to basically conduct so much more operation within the realm of cyberspace and by extension in the blockchain is again, this key decision in Huang Junsang, which basically is the court's very first decision allowing us to serve legal process using digital means. And in turn, it gave us a foothold into basically targeting otherwise entities that are hidden behind a wallet address, and keeping in mind, in my view at least, or my opinion, and wallet address is no different from a physical residential address that's otherwise unassignable.
Well, perhaps then we can go and turn to Huang Junsang. What was the moment for each of you when you realized that the traditional ways of serving documents were not going to really work in that case?
Because I was the judge, I suppose the moment came when counsel told me that. But it is a case that by the time this particular decision had been made, there had been a number of previous orders and directions relating to an ever-expanding group of defendants and therefore an ever-expanding amount of documentation. And I think it became clear at the point of this particular application that, not least if you've read the decision, there were about 13 defendants who were served with masses of paper overseas, and they sent it back, pretending not to know each other, but somehow they sent it back in one big box, all wrapped in the same way. Not very clever, as I think I said. But it became apparent that that sort of very document-heavy and expensive form of service was going to become increasingly unwieldy in that type of case. And therefore, I think that's when the practitioners, Joshua and Moses, started to think about an alternate way of dealing with this.
Yes, absolutely. I was very fortunate to be working with Moses Park, which is a CUHK alumni, of course, that I believe Steve should be very proud of, that's willing to run innovative ideas with us. And it's not just an issue of, in this particular case, the defendants were human beings physically present, but the manner that they're evading service meant that it's actually far more sensible for us to serve electronically, because in today's day and age, people are more likely to have an email address. And unlike a house or even a rental property where you're more likely to basically change over time, you are not going to sell your email address to another person. Same thing with wallet addresses in future cases, of course, as well. In that sense, by basically using technology to mitigate a lot of the hardship that asset recovery lawyers were trying to overcome, it really enabled us to pursue against the litigants in a far more efficient manner, which is actually one of the underlying objective of the courts at the end of the day. And by comparison, I still remember reading some of the cases that asset recovery cases that were happening at that same moment of time. There were firms that were literally spending six figures in cost just serving papers. And that makes it a rich man's game if it comes to asset recovery, which is quite unwieldy and unaffordable for victims which might have limited financial means or might have lost everything as a result of a particular incident.
Thank you. So the idea was service via the secure data room. And do you want to just explain to everyone, in case they haven't read the judgment, how that actually worked?
Well, I think the judgment, which is one of the most cited one in my students' assignments as I teach, of course, one of the way that His Lordship really cleverly articulated is how the analogy of using a data room providing that access link is no different from putting all that documentation into an envelope. And of course, the nature of the game when it comes to service is drawing the other side's attention to the fact that there are civil proceedings present. And that actually makes sense when you go into future cases, such as ones we are dealing with assets dissipated into wallets. We want the holder of the wallet, for example, their attention to be drawn to saying, look, our client is claiming rights to these assets. Your attention has been drawn to the fact that it's under civil and potentially criminal investigation as well. And these, at least as a way of preserving your client's right in a smart and efficient manner. And in future cases, of course, there are instances where electronic service became the only method where you're able to contact the other side.
Yeah, I think my thinking behind it, and I'm sure will be the same from many other judges, is to look first at the rule, which I think I did, Order 65, and it was a broad rule, so there was scope for whoever drafted the rule in the first place may not necessarily have had secure rooms like this in mind, but certainly the rule was broad enough to deal with that. I think the next thing was to recognize the change in circumstances and technology, and then to argue from first principles and the key objective of achieving service fairly to all parties, fairly to the people being served, but also with a sense of fairness and proportionality to the claimant in the case. Keeping in mind the core objectives which are available in the rules, and the requirement, amongst other things, for judges to be active in their case management, to bring that activity. That's not the same as activism. I saw something about activism in the flyer. I deny I had anything to do with writing that bit, but active management is an appropriate thing to do. So that's really the thinking path, and it led, I think, as you said, to the concept that, well, what's really the big difference between a big pile of papers in a room and a big pile of papers in an electronic room, to which you either have a physical key and you can go in and read it, or you can have the electronic key to allow you to read it.
I think following on from that, that's the idea. It does sound quite technical. So was there any concern about fairness? Did you have any worries about the fairness for the parties in there accessing this?
I don't don't think actually that is terribly technical, is it? I mean, the idea of a data room requires technology, but for me, it wasn't an unfairness, because the key about service is to provide notification of the proceedings to the person being served and an opportunity for that person to read the relevant documents which are being served. I mean, if I give you a huge pile of paper, I'm giving you notice, I'm giving you the opportunity to read it. You don't have to read it. You may not read it. And it's the same with the data room. But so the point is really the notification, the opportunity to read it. That covers most of the necessity of fairness in that service process.
Well, one of the memorable moments I have working on that case is that one of the things that we focus on in our affidavits in support is where we have draft letters explaining to both the courts and basically showcasing how notice will be given to the other side. We basically explain step by step to the intended recipient how they can, what the nature of the documentation is that we are serving them, how to gain full access, and they can a contact point that they can contact if there's any questions or anything.
And having a court approval of that is obviously important.
Yes.
And I think I said it towards the end of the judgment that it may not be the right thing in every case. So fairness may require not to do it this way, depending on the nature of the case, the nature of the defendant, and so on. So it's not a one-size-fits-all.
But I would add that because of the very nature of how we did it, it's actually far more clear and articulate than most services affected in modern days. For example, I have heard a lot of clients over the years that came in and said they received a pile of papers and they had no idea that it was actually a litigation in progress until when they're very close to the deadline for acknowledging service. So that does happen. By streamlining and having it crystallized into a single page letter, clearly articulating what is going on, actually slim down a lot of paperwork that built up over times, because paper documentation have also increased substantially over the years.
Thank you. If we fast forward from the secure data rooms then to tokenized injunctions and on-chain notices, what do you each see as genuinely new and what is simply an extension of the same logic? Do you regard tokenized court orders as a revolution or as an evolution of existing procedural tools? The judge, would you?
For me, I think it's an evolution, not a revolution. The technology underneath may be revolutionary, but the process of the use of the technology seems to me just to be an evolution of the previously used tools. Don't forget, from data room, the next case I think I dealt with was a QR code server on the airport authority case, and it's always it's looking at perhaps a different technological way of achieving the same underlying objective, and so taking a new piece of technology, which itself may be revolutionary, but actually just using that is, to me, an evolving part of an evolving process.
Well, the way I see it is technology is always ever changing, and how humans interact with it is basically quite natural. Take, for example, the first contract that's recovered in archaeology, which Professor Gallagher should be very well acquainted with, is on stone tablets. So just because the medium of how information is recorded doesn't mean that there's a drastic change in requiring change of rules saying that you must do certain things. I believe that one of the beauty behind common law courts is that we're able to be flexible enough to get the relief needed so that the order can come in where we can serve the documentation in the best method possible. However, of course, we do see in the airport authority case, for example, we do see that because these are still newer decisions, not all the practitioner might actually know how to apply it properly, nor and potentially some of the other members of the judiciary might not be familiar with it. So it does take time for us to basically have that evolution absorbed across spectrum. Take tokenization order, for example. We have been doing this for past few years, actually. The first NFT service came out back in 2023 when Ravenscroft did that case. But again, each case is quite situational, as His Lordship quite rightly pointed out. Not every single case is appropriate for service by NFT, for example, just because there's a blockchain element on it. Take if you're interacting with a wallet that only have stablecoin transaction, it does not make sense to deploy an NFT that requires a specialized platform to read it, to actually take notice. And we do see practitioners struggling with that as well. In other cases that is trying to adopt some of our innovation approach, for example, we've seen them having, what I would see as a potential red flag that might lead to a discharge of an ex parte order, for example, is where they labeled the token that they deploy in a quite suspicious manner, saying something hack. So a recipient might actually accidentally think that it's a malicious token being deployed and be reluctant to have their attention drawn to the fact that civil proceedings have in fact been commenced against them. So all these factors are basically new that have to be dealt with both by the practitioner and by the court. And of course, there are issues of because crypto and things in cyberspace is, of course, borderless, we do see issues. For example, even in our first NFT service case back in 2023, we already have escrow provisions, but a lot of times practitioners might be reluctant to activate it because if assets are actually located overseas, for example, are you co-opting assets into Hong Kong's jurisdiction without the right court order in the right jurisdiction? These are all emerging issues that I see the courts and practitioners might have to address in the coming days.
Do you still see a problem? The judge said this earlier about understanding the technology. Is there still a big issue, do you think, with lawyers and even...
Well, I'm not supposed to be advertising for my class, but I will have to say yes. It's not taught in the academic setting. For example, a lot of the new case precedents that we have came up with that came out as we are practicing. So lawyers that have been 10 years, 20 years in the practice is not going to have become aware of these new emerging tools that can enable them to serve their clients in that manner.
I think we all know about legal conferences that go on around the world, and there's a hot topic from time to time, and it changes. Obviously, this is one of the hot topics at the moment. So there is the ability to find out. I think it is incumbent on lawyers who might come across this to educate themselves sufficiently. Within the judiciary, the JI, the Judicial Institute, which is helping to keep up the education standards within the judiciary. There are papers that are written that we have a judge's portal where there's information which is readily available to us. So there are resources to which we can turn, certainly internally, and I think which are available. The problem, of course, is that people are often very, very busy in what they do, and they don't necessarily have time to just go off and study something in case it might happen, unless they've got a particular interest in it. And you get, of course, you get very techie judges and you get very Luddite judges. But at some point, the case comes before them, they'll have to be educated.
Thank you. So both of you have had to make judgment calls under legal, technical, and reputational uncertainty. Can you share a moment when you thought, if we get this wrong, it could set a bad precedent, and how you managed that risk while still allowing innovation to happen? You have to start with the judge.
Well, I was going to say that's what the Court of Appeal's for. Of course, judges vary in their character. Some people like the idea of making new law. Some people are a bit nervous about that. I think judicial confidence is very important. Of course, what you try to do, I think, is to decide the case on the merits as you see it. You can't lose sight of the fact that it might become a precedent and might be used in a particular way. But I think you have to decide whether that precedent is one which is sufficiently good that it works for the purposes of the present case. And as I say, there is the Court of Appeal. If you've got it wrong, or if they think you've got it wrong, which may not be the same thing, then they can change it. Reputational risk. Well, obviously, you don't like getting it wrong. You don't like being told you've got it wrong in general terms, but it's an occupational hazard for everybody to be told that. I don't think there's a significant reputational risk unless you're going way outside the possibilities that are open to you on any given argument. And it's relevant to perhaps some of the other points we might discuss, but in the Hong Kong scenario, we have an adversarial system where judges are heavily reliant on the way in which cases are put to us. And usually the argument across the two sides, sometimes three sides, is what will identify the possible range of decisions. And it's pretty rare that you will go outside that. I would think it's never that you would go outside that without first raising it with the parties themselves. If you come up with a new idea of your own and you think you want to extend something into a new area, you're not going to do it without asking. And that's what counsel solicitors are there for, to help. We like to think we get it right. We want to get it right, and we have the help to help us get it right.
Sure, do you want to?
Well, as a practitioner litigator, from my perspective, it's when you're a litigator, it's all the glory or all the shame. So that is quite stressful. And a lot of times I do reflect back as I realize that I only enjoy litigation work after I've won the case, not during the process at all.
Oh, that's a big mistake. It's a big mistake. Firstly, how can you hope to have a decent appellate practice unless you're constantly losing at first instance? And secondly, I remember years ago, Silk said to me, "How many cases do you lose? Do you lose quite a few cases?" I said, "Yes, quite a few." He said, "Do you think you lose more than half your cases?" And at the time, I thought I did. So I said, "Probably more than half." And he said, "Oh, that's a very good sign. Anyone can win a winning case, but if you're losing cases, they're coming to you with the difficult ones. So if you lose some difficult cases, that's not a bad thing.
No, but
you win it next time."
Yes, but I get a little bit too emotionally attached, and I might lose some hair along the way.
Well, that happened to me, you can see.
Hence, you're the more learned amongst us, of course.
Grass does not grow on a busy street.
Yes, but as somebody that started with often technology, of course, I do like to test with innovative ideas. And if at the end of the day, you have to judge whether it goes towards helping your clients or not. If it does, and you give the risk benefit assessment ratio, you go for it. And nothing ventured, nothing gained at the end of the day. And these are areas that, unless you're willing to venture forward, a lot of issues are not going to be solved. Can you imagine if it hadn't been for these cases, we would have none of the reliefs that would come consequentially for litigant that is hiding behind cybercrime. And well, the unfortunate thing about COVID is that the work from home practice meant that there's a skyrocketing of cybercrime that came as a result of that era. So these are really reliefs that came very timely, I would say.
Thank you. The next question, I think we've already really dealt on this. Of course, the question was, have you seen examples where digital tools, data rooms, e-bundles, remote access, or even blockchain-linked devices actually made proceedings more accessible and understandable for parties? Well, I suppose they wouldn't have been developed, otherwise they would have been used in these cases, unless they were actually.
Yeah, I think they're intended to meet the targets of accessibility and comprehensibility. And I agree with you. I think that a pile of documents is sometimes more of a concern than the ability to go to something electronic. Although if you come to my court, you're still seeing quite a lot of piles of documents. But we're moving in the right direction.
Good, thank you. In fraud and crypto disputes, where you deal with on-chain assets and pseudonymous wallets, where do you currently see the bigger bottleneck? In the way the law understands those assets as property, or in the procedural tools available to trace, serve, freeze, and enforce against them?
I would say both issues are quite crucial, because if you don't know the procedure on how to target the right defendants, then it comes back and bites you back at the end of the day. So we have a number of cases. So that goes back to your earlier question. What happens if you commence a set of proceedings? Your drafting of the initial pleadings are based on incorrect concepts. It can really come back to harm you if you got the reliefs that are completely ineffective. But that again is where us as lawyers, we are supposed to assist the court in helping through that particular process. So the education is there's still a huge gulf when it comes to the education of practitioner about knowing how to basically utilize these tools and even knowing what are the proper applications that might be needed. Then it falls to the factual matrix, which you say, what are the nature of these assets? Is it capable of certain judicial reliefs? Well, I've seen cases where there are pleadings where they treated crypto assets similar to fiat fraud, but that's incorrect because it has negated the underlying assets. And whether you take that piece of court order or even judgment at the end of the day, and you go to say one of the stakeholder within the crypto ecosystem, because at the end of the day, everything is on the blockchain. That means there's a player involved, there's a tech player involved. There are ways of dealing with the assets. Is your court order going to enable you to deal with the assets? For example, if you say that if you treat crypto asset as a type of similar in the garnishy way, as if it's fiat money, then you're not going to be able to have access to burn and remit reliefs that stablecoin issuer will need, for example. And litigants being mindful of that early in the proceedings will have huge implication on how it plays out both procedurally as well as how they prove their case, because they might get through the entire process and end up with something that's not effective.
Judge, have you got any?
I agree, and there is nothing I can usefully add.
Well, we may come back to that issue of digital assets as property a little bit later on because of other things going on in the world as well. Hong Kong wants to be a Web3 and fintech hub. From your vantage points, how much does it matter that the courts are seen as technologically confident, open to new methods? Are you already seeing signs that parties choose Hong Kong because of this, or is it still more of a nice extra rather than a deciding factor?
I would have thought that it does matter that the courts are seen to be capable with an appropriate degree of confidence of handling these matters of technology and being open to new methods of dealing with them to ensure not just to have a just answer to a complaint, but also potentially to take the relevant steps to preserve matters in the meantime and to have something against which to enforce a successful claim later. Whether parties are already choosing Hong Kong because of the decisions that have already been made here, and of course they're being made across the range of different types of court, first instance in particular, perhaps in injunctive matters, but also in the Court of Appeal, a number of different judges. I would have thought at the moment it's probably something additional, because where people choose to litigate, if they're choosing in Hong Kong, will probably depend on other features at the moment. But it may become more and more important if there is a confidence in the Hong Kong system, as I think there should be.
Well, I've been actually throwing this question quite a lot when we were going through the legislative process with the licensing regime for virtual assets trading platform. And one of the things that I kept stressing in various venues is that you cannot legislate your way to a perfect world, because whenever there's a new issue, one of the first things I see a lot of LegCo members or even the public will come out and saying, oh, there are gaps within Hong Kong's law or something like that. And the key thing that I always say is there are three pillars, of course. You need the laws in place, Then you need the practitioner or even the Department of Justice in criminal matters to have the experience in dealing with such matter. And finally, whether the laws are efficiently crafted, especially the newer laws that we are seeing cases reliant on, really comes down to whether it's properly adjudicated in the courts. That gives people that real confidence. So I would always say that it's premature whenever we see headline articles that say certain jurisdictions have this new piece of legislation and therefore they're the premier jurisdiction, because you don't know how that particular legislation will play out in the long run. So I would say the judicial elements is actually the final cornerstone that actually cements whether a jurisdiction will eventually become mature in dealing with a certain nature of be it is crypto a new asset class, or be it if it's a new environment that we need people to be more familiar with dealing with. So these are the three pillars that I see and we do see a lot of new laws have yet to be tested in courts, because while a lot of times private parties are very afraid of, say, regulators, once in the courtroom, regulators are only one of the parties before the bench, and they could be correct or incorrect as well. So I would say that the judicial element is in fact the cornerstone that will really define whether one particular jurisdiction is effective or not.
Well, following on from that and from something we were discussing before the seminar as well, novel methods, and we're seeing these novel methods adopted in these cases, they take time to permeate the system. What challenges have you seen when it comes to adoption by other judges, especially at first instance levels, who may not have seen these applications before, and practitioners who may rely too literally on written judgments or misread the factual matrix in trying to apply them?
Well, I think when it comes to judges, I mentioned the adversarial system before that we have. It doesn't really matter what the point is if there's a realistic likelihood or possibility that the particular judge or judicial officer won't know about it. It's a fine point of law, it's a fine point of technology, whatever it is, then it is part of the duty, the advocate, to assist the judge or judicial officer to understand it. Of course, when a decision has been made or when a couple of decisions have been made on a particular topic, then you would hope that that does permeate. I know there are some very diligent colleagues of mine who read the new judgments as they come out every day. I don't claim to be one of them, but I do read the ones that I think I might be interested in. And we all keep an eye on what each other are doing, sometimes with some jealousy. And I think the problem may be at the slightly lower level in the judiciary, say at the master's level, where a lot of the questions like service and so on will first arise, and if it's not immediately in an injunctive capacity or an application, and making sure that there is enough knowledge across the decision makers is part of the judiciary's task, but with the assistance of those who appear in front of it. If that's my mother, tell her I'll call her back. What do you think, Joshua?
I agree, because one of the cases that you have actually dealt with, the airport authorities case, as I was reading that judgment, I recall that one of the facts mentioned is how because the master refused to grant leave to use more novel methods of service, the airport authority actually have to spend millions on advertising about the case in newspaper. Again, instant midlife crisis. I was like, am I in the wrong industry? They just made millions overnight by advertising the writs. And you do struggle because we do get more conservative masters as well. And unless there is an ex parte application, most applications are brought before the lower level of courts, where again, it's up to whether the litigants have sufficiently assisted the courts with coming to a decision, that they cite the relevant case and the relevant legal principles sufficiently that give the lower courts also confidence to make that particular decision. I'm not in a position to judge because I wasn't handling those particular case, but I do recall one of the complaints that one of the magistrate made, for example, in a few years back, is neither of the parties were assisting the court in certain instances by submitting case authorities when it came to sentencing. So these things do happen, and whether we are able to have a more perfect system at the lower levels is to be seen. Of course, I would one of the articles that I published for the Hong Kong lawyer in the past is maybe AI-assisted judiciary is a thing that we can consider. But of course, in recent times, we have seen a number of controversies where practitioners have to deal with hallucination as well. So with each new emerging technology, there is there are, of course, opportunities as well as detraction. So it remains a way that we iron out as the situation develops, of course.
And to go back to one of your earlier questions about fairness, of course, one of the elements of fairness is consistency in approach. So we certainly would be wanting to do all we can between us to promote a consistent way of dealing with the same or similar matters. Subject, of course, to trying to persuade someone to take it a little further this time.
Yes.
Yeah.
So following on from this, every innovation creates people who feel left behind. In the shift towards digital litigation and blockchain-related tools, who do you worry about most? Self-represented parties, smaller firms, overseas defendants, or even judges and lawyers who are less comfortable with technology? And what can practically be done to support them? We touched on some of these things.
I think we have. I usually worry most about myself. But of course, judges and lawyers, you would hope, can be the beneficiary of education, Law Society, Hong Kong Bar Association, lectures and seminars and maybe workshops. The judges, of course, have the JI, and there are materials out there. And people, I think, will read around. If they're interested in the topic, of course, they'll read around. If they feel that it's likely to come before them, they'll read around. Self-represented parties, I think you just have to take them as they come. They vary enormously. Some of them will be super technologically savvy, others will not. Smaller firms, I suppose, will have fewer resources, generally fewer financial resources to keep up with the latest things. So you'd have to keep that in mind. Overseas defendants, I'm less worried about because often the overseas, well, they're defendants. And if you're dealing with a technology case where they are the defendants, then you're probably dealing with them in the digital terrain that they themselves have favored.
Yes.
Which is a lovely phrase which I've borrowed from an American case. So yeah, if you're going to their digital terrain because they've chosen it because they favor it, I don't think you need to worry too much about them.
Well, going back to the education factor, of course, when I started teaching, it used to annoy me that students are falling asleep. Then I realized how boring my materials were. And then I was like, oh, wait, they're actually so comfortable sleeping. It's something that you should be proud about because you're solving their insomnia, right? But that having been said, yes, we do have a lot of CPD mandatory requirements, for example, when it comes to solicitors maintaining their practicing certificates. And ongoing education is, of course, something that's important. But what we are seeing is entry-level associates or trainees, for example, might have the advantage of having the latest information from the law school, and whether the law school is able to basically catch up and offer their students the latest technological practice in both the JD and PCLL program or LLB or MPCLL programs.
And what's the answer to that?
The answer is we are providing these things. So thank you very much, Joshua, for promoting this. I know our colleagues at the other two law schools are doing this as well. I don't want to say we're the only ones, but I think all the law schools are familiar with this. I have colleagues in the room who are actually teaching technology courses as well. So
Well, the technology part, but are you teaching them in insofar as how to do e-filing, for example? That I remember was not taught in any of the law school, or preparing the electronic bundles. These are something that has really evolved, and we do see trainees coming out and struggling at the same time.
we have a PCLL course, which is now focusing on this with a very distinguished local practitioner.
Very good.
Teaching on this, I won't publicize too much about it. But thank you for giving me the chance to say, yes, we are providing these services. So yeah, it's a good point. The education to do with this. Again, I think this was raised earlier. A lot of people get very worried around the technology, and then the technology, how it works with the law and the process of law.
And can I say one last thing on it? The question is about who gets left behind. I suppose technology seems to be moving at a pace where everybody, apart from the people who are creating that technology, might be left behind. So the incentive to keep up to date, at least up to the last date before the last thing that was changed, must be there, because learning the whole thing from scratch is going to be increasingly difficult.
Thank you. So around the world, we're seeing experiments with online courts, AI tools, and crypto-specific remedies. I suppose we had to get to AI at one point. Are there particular jurisdictions or projects you look at and think that's something Hong Kong should borrow? And others where you say that goes too far for our system?
Well, I've recalled seeing a judge slamming a litigant recently in the US for using an AI avatar as his legal counsel. So a lot of times litigants in person, they get overly imaginative of where technology can go. Maybe they've seen it on YouTube or a movie, and that's where they think the technology is. You need boundaries at the end of the day. But of course, I do see a lot of good introduction of electronic courts that are used in, say, Australia, where I know practitioners from that region saying that they're very proud of being based in Thailand or Hong Kong, and say they can do the entire case without stepping foot back in Australia, as a potential next evolution for how courts can be conducted. At the end of the day, Hong Kong is one of the premier financial center as well. So we do see Hong Kong as one of the key jurisdictions that do a lot of adjudication that gives confidence to the rest of the Asia Pacific financial markets. So these are things that we do have to keep abreast in our practice.
And I think we have to look at what other people are doing in other jurisdictions, whether we want to borrow from it, as the phrase you use, or adopt parts of it, or suggest from us to them what they might do. I think that has to happen, so that we're all coming on. I mean, one of the things I read recently is a slight change to the English approach in whether an NFT service needs to be the alternative or a substituted service, because traditionally you had to do something in the old-fashioned way first, and only then you could get a substitute. Then I think people moved to the idea, and it's certainly been happening in Hong Kong as well, that you can order both the traditional and the alternative side by side. You don't have to wait until the first one has not worked before you have the second one. You can order them side by side, particularly if you think it's more likely that the alternative will bring the matter to the attention of the defendant. But now it's being said, well, why do we even need to do the original? Why do we need to wait for it to go wrong if we're confident that the best way to achieve service is to use an NFT? And I see a lot of force in that myself.
Well, I still remember one of the first cases I've done in my legal career deals with actually service as well. And one of the decisions that in that particular case, one of the other side, as I recall it, intentionally served the address that we already indicated to them not to serve it on, because it's not one that's manned, and they actually did not disclose that to the court when they get service out jurisdiction. So one of the more memorable quotes from that decision, even though it was delivered orally by Registrar Kwong at that time, is that there should have been a request for concurrent service where, yes, as a matter of fairness, you should serve at the registered address. That to satisfy, of course, existing legal requirements under the company ordinance, for example. But at the same time, you should disclose to the court why the other what other address is known to the plaintiff in that particular case in order for it to be effective. It goes back to effectiveness and fairness of proceedings, which are the underlying the objectives that the court is upholding at the end of the day.
If you imagine a complex blockchain dispute in Hong Kong in 5 years from now, what would you like the user experience to look like from start to finish, from filing and service to case management and hearings, through to enforcing a judgment on-chain or across borders?
Joshua, you better answer that one.
Oh, well, why 5 years from now and not today? We are seeing more and more incidents that have resulted in both civil and criminal actions in Hong Kong that deals with virtual assets related matters. Of course, in one of the largest crypto heists actually occurred, I wouldn't say in Hong Kong per se, but connected to Hong Kong, the Bybit hack that 1.5 billion was stolen by North Korea last year. And one of the things we are seeing is technological tools have enabled very efficient and speedy layering when it comes to crypto assets as well. But one of the other beauty behind crypto assets is everything is recorded on the blockchain, which is why it's so much easier to trace. You don't need to go back to the court for a banker's trust disclosure order each and every single round. I think those cases are going to play out very interestingly in the coming days, and whether Hong Kong courts have a locus to play in those particular cases remains to be seen. But I do see that within the common law realm, which is much larger, of course, all these things is going to have a role in influencing one or the other. On the flip side, I wouldn't say civil case. I would say earlier this year, there was a report from Cointelegraph actually about how there is actually a salvage claim or more like an adverse possession claim that occurred within the blockchain where older generation of Bitcoins that were in dormant addresses, somebody deployed, interestingly, tokenized legal notice saying that they're claiming the rights to that particular address, which basically the focus of the news is, of course, whether the encryption had been breached, of course. That was the focus of the news. But we're seeing legal solutions actually being applied that are really created from Hong Kong or similar jurisdiction being adopted across not just in Hong Kong, but a much wider geographical reach. So in the past, Hong Kong rulings might only be influencing Hong Kong, but we might be seeing how it can be echoed in, I would say, even though the US is supposed to be a common law jurisdiction, it's a mix, right? I would say that we're seeing far-reaching consequences, of course, or impact in areas that we never imagined before.
I think you'd be looking for a case which is smooth from start to finish. Obviously, electronic filing, service electronically if that's the appropriate thing for the case, and in a complex technology case, it probably would be. Case management and hearings. Well, case management is going to be easier through if there's a proper e-filing system which is accessible by the person managing the case. Hearings, I think that people are discovering, aren't they, again, after people have come back to the office after COVID, that there's quite a lot of value in having the people in the room. My own view is that case management hearings with the people in the room are probably preferable to those with people not in the room. And in Hong Kong, that's not usually difficult because of the simple geography of the places. People are not traveling long distances or expensive travel to come from wherever they are in Hong Kong to the court building. Often you get more done when people are there, and you can be a little bit more perhaps Solomon-like in your decision-making for management purposes. Enforcement, well, that's going to come down to the technology.
Well, we're going to see a lot more interesting facts. One of the papers I've theorized in the past is whether smart contracts have a role to enable automatic enforcement of judicial or even arbitral awards. That is, of course, more theory than concept, but we will definitely see how that works. We are seeing other technological evolution in other judicial system as well. Civil law jurisdiction have begun using AI in their adjudication. But of course, the theory behind it is because it's a prescriptive model, it's far more easy for those jurisdictions to adopt these technologies than in common law jurisdiction, which really enable the flexibility to adjudicate the matter in a more, I would like to say, conscientious manner, but that's how I would frame it.
Thank you very much.
And we'll see how that plays out as well. At the end of the day, technology is always a tool to assist, not the ends of the entire process. So we are going to see a very drastically different society in the coming days, for sure.
Thank you. Well, I have to agree, by the way, of having people in the room. It's very nice. We have, I think, 400 odd people online, but it is very nice to have you all in the room today as well. That sort of interaction. And I'm a little bit worried now that we're going to have to teach in our land law adverse possession of crypto. It's going to be a strange. I'll tell my colleague, Professor 𝗦𝗲𝗴𝗶𝗲𝗀, we'll should talk about adverse possession of crypto as well.
Well, I mean, if you think about it, can a wallet address be treated as the same as a physical address? In that case, maybe potentially a lot of land law concepts might spill over. A lot of times, the beauty behind our law is I always see a simpler time, right? If you look back 100 years ago, a conveyancing lands transaction, the documentation is far more slimmer than what we have today. We in most conveyancing matters we have hundreds of pages of document, but 100 years ago it's only a few pages. So, but it also speaks to how everything have the same root. So conveyancing SPA, the process is quite similar to, say, corporate M&A. And we'll see how that influences as well.
I think this verges on the heresy for property lawyers.
Of course.
This idea, but let's move on. There's always a tension between speed and safeguards, especially in urgent fraud cases. How can courts and practitioners move quickly enough for digital tools to be effective without compromising core principles such as open justice, the right to be heard, and proportionality? Again, I think you touched on some of these things.
Yeah, I mean, I think just taking the service point, the electronic service of somebody who's not in Hong Kong via a data room or NFT or something like that, I would have thought is a way to safeguard fairness and improve speed. You don't have to cart a big bundle of documents through a courier across a plane ride and then deliver them somewhere. So it can be used effectively. You've just got to make sure that it suits the case, its particular circumstances. And I would have thought somebody who's served very quickly, who has the opportunity to look very quickly, will then have the opportunity to exercise their right to be heard very quickly. And it may require practitioners and judges to be available at short notice. There should be a judge available at short notice in any event. And I think just that willingness to recognize that because of the nature of the beast, then some speedy or very speedy response will be required.
From my experience, I would say we need both the courts, practitioner, and the technology to be speedily available as well, because we do get court orders that are granted after hours. But the good thing about for example, virtual assets related cases is you can have instant deployments that can secure your client's right on the chain. And if you do it properly, it will announce to the entire world why that particular set of assets might be tainted. And you're actually preventing other people from falling victims from receiving tainted assets, for example. So technology does go in a way of speedily enabling justice to be effective within this particular space. But of course, the speed is everything. Then again, I will also add that by digitizing the entire process is actually making justice much more accessible as well. Imagine if you have foreign litigants and you're served with several bundles of document or entire box of files, you're not going to be able to look for a lawyer at your local jurisdiction to deal with it. You're going to have to ship it over back to the home jurisdiction, Hong Kong, for example, to get advice. You're actually adding a lot of costs incidentally. There are far better ways to serve both sides of the table, actually. Yeah. So at the end of the day, I would say this solution doesn't just go towards helping the applicant, it also helps the recipient having the opportunity to be heard in a timely fashion, because he or she wouldn't have the trouble of carting the files back to the originating jurisdiction.
Thank you for everyone who's joined us
Thank
online.
you.
Thank you for coming. Yeah.
For everyone who's come in the room. It's been great to see so many people here. And thank you for two great speakers. And yes, we should say an early Merry
Merry Christmas.
Thank you. Thank you.
Thank you.